I have, as I said, a bunch of questions, but I will try and defer and just begin with a broad one. And it's something that comes up in, I think, both presentations. And Alan, you mentioned at the beginning of yours the need for these regulations to plug holes in existing provincial schemes. And I just observed that's unusual to see the federal government thinking that there are holes in the upstream oil and gas sector where they should have a role. By and large, they've been quite deferential to the expertise in the provinces, especially in Alberta. They basically think the Alberta Energy Regulator knows how to run things. And I wonder why it's different this time with greenhouse gas emissions. It also comes up, I think, in Professor Lucas's presentation, where he talked about the reticence, apparently, of the energy regulator to get involved in this sort of thing, that basically they want to kick the can to Alberta Environment. Now, that is not something that the energy regulator has done with respect to other pollutants. It hasn't been shy about sour gas, for example. It hasn't been shy about getting involved in other particulates. It does seem, though, in both cases, greenhouse gas emissions are thought of differently. And I just point out, in terms of the locus of the federal regulations, it's Environment and Climate Change Canada. It's not Natural Resources Canada that's doing this. There hasn't been a mandate that's been added on for the National Energy Board to look into the upstream sector. And traditionally, I think we would have thought of these as resource use and conservation problems and given them to those particular agencies, the provincial energy regulator and something like the NEB or even Natural Resources Canada. But it seems different for this type of pollutant. And I wonder if you comment why you think that is in terms of how these are treated.
All right, well, thank you, Owen. First of all, your point about traditionally the federal government has deferred to Alberta and Saskatchewan and British Columbia. I still believe that this is in large part the case, and the reason I say this is as follows. I gave you one example when it comes to the hydraulic fracturing of oil and gas wells. In the new federal regulations, they basically incorporate the Alberta and BC standards, where they say, it's in section 11, details are in my paper, as long as operators satisfy, and these are 2016 standards, so they've been updated, Alberta and BC, we recognize those standards are adequate for the purposes of minimizing emissions. There's another section where, when it comes to efficiencies, i.e. the amount of gas that needs to be captured and not vented, another section of the regulations where they say the Saskatchewan, Alberta, and BC standards, again, are acceptable for that purpose. So I think we're seeing a recognition that the Alberta, BC, and Saskatchewan governments have far more experience, and they wanted to capture the best of that experience, and for example, the two examples that I've given to you. But if you recall, I said quite a number of what are clearly required practices in the new regulations are recommended practices in the provincial schemes. And so it's really the impetus because the provincial schemes in Alberta, Saskatchewan, and BC, they draw heavily on voluntary industry practices. The emphasis is on what's it going to cost, what's the most cost-effective way of dealing with this, which is understandable from the provincial government standpoint, but the new regulations are designed to address specifically the issue of climate change, where these oil and gas conservation schemes, which, as I say, started in the 1930s, climate change, what was that in the 1930s, right? So I think that's the difference, and keep in mind that these new regulations, which, as I say, parallel what we've seen in the United States, are a reflection of the commitments that our Prime Minister Trudeau made to President Obama and at Paris, and what we see in the U.S. Basically, the EPA now dragging along the state, and there's a federal regulator there called the BLM, which plays a much larger role than historically our federal regulator in Canada has. I mean, the number of oil and gas wells and facilities on federal lands is a fraction. They're basically on Indian reserves under the Federal Indian Oil and Gas Act, military bases, and offshore. And the other thing I didn't mention, but it's probably obvious, is these new federal regulations create a uniform standard. But most of the emissions are from these onshore facilities in Alberta, BC, and Saskatchewan. And to me, it's common sense. Plug the leaks, reduce the venting. Ultimately, what's going to happen, what is relatively inexpensive gas, which we use for furnaces or whatever, the price of natural gas will increase. The companies will pass this on to all consumers down the road. But it's responding to the issue of climate change. That's my take on it.
On your other point, Owen, energy regulators have traditionally focused on energy facilities. Okay, and that's true of provincial regulators like the Alberta Energy Regulator, and also federal regulators like the National Energy Board. So it's not surprising to see that in the Alberta Energy Regulator. On the federal side, however, as a result of Bill C-69 that has reconstituted the National Energy Board, one of the criteria that's found its way into the statute is upstream and downstream greenhouse gas emissions, because the National Energy Board, some of you will recall the debate around the Energy East pipeline, and it was the federal government's insistence that that part of it be remitted to the National Energy Board panel that seemed to be a major reason for the cancellation by TransCanada of that pipeline project. So, but I guess my point is that energy regulators have taken the view that the limit of their jurisdiction is the facilities that they are constituted to regulate. So it's no surprise that they should behave in that way.
I can't resist, but it's because you've used the word pipeline, so I feel I can ask this question. It doesn't have much to do with your presentations, but with the Trans Mountain Pipeline project, and assuming the feds get through the consultation requirements in one way or another, I'd just be interested in your thoughts with the project now being declared a work work under federal jurisdiction under the Constitution. Will the province of British Columbia or creatures of the province of British Columbia, like municipalities, have any regulatory authority now that it's a work to the national advantage of Canada?
These pipelines actually have a lot to do with oil sands oil and consequently with oil sands greenhouse gas emissions, right? So that emissions is definitely, the whole area of emissions is definitely a factor in all of this. If you look at the opposition that has emerged to the pipelines. Yeah, this is the constitutional jurisdiction concerning pipelines is something that I've looked at over the years. My conclusion is that there's pretty clear federal jurisdiction under Section 9210C, so that's of the Constitution. That's works and undertakings that extend beyond the boundary of a province or connect to provinces. Okay, so that includes international pipelines. So there's that, and then there is the other part, the 9210C, the declaratory power, right? In principle, the federal government can declare a particular work as a work for the general advantage of Canada, and as a result, give the federal government complete jurisdiction over that thing, whatever it happens to be. And this has been done in a few cases. Atomic energy facilities, that's the basis for federal jurisdiction over nuclear facilities. And it's been done in the grain trade. The declaration there that was made half a century ago included individual grain elevators. It was really kind of a silly process. That power is there, but it's doubtful that a federal government now would use that power. It's basically a dormant power in the Constitution. So I know there's been some discussion about this. So as I say, my conclusion is that there's really not much argument about federal jurisdiction concerning these major interjurisdictional pipelines. I haven't mentioned indigenous rights, however, and that's a whole other story.
Question, at least for Alan, if not also for you, Al. It's a little counterintuitive for the American lawyer to be asking the Canadian what's the status of U.S. law currently, but I'm going to do that. In respect to methane regulation, I know that at the very beginning of the current Congress, one of the regulations which they sought to repeal under a very infrequently used law called the Congressional Review Act was the Obama administration's methane regulations. It was only because of the last-minute vote of John McCain, the late John McCain, who decided not to vote to repeal them, that law and those regulations stayed in effect. I do know that Secretary of the Interior Ryan Zinke, immediately after that congressional vote to retain the methane regulations, announced his intent to work with Congress to repeal them, and presumably to put in their place much less stringent regulations. I'm actually not familiar, though, with what the current status of any efforts to repeal are, let alone to replace, and I'm curious if you do.
Sure. In the course of looking at the U.S. situation, there's a number of lawsuits in which the state of California is a party to one of the lawsuits. One of them has been brought against Secretary of Interior Zinke. So what we're seeing in the U.S. right now in terms of the lawsuits is actions basically in response by the state of California and a number of environmental NGOs, basically to return to the Obama regulatory framework that you're referring to. There is what's referred to as the hydraulic fracturing rule, specific to hydraulic fracturing, these oil and gas sites, which I understand has been repealed. And this is all in response to I think the framework as far as, I think it's driven in part by politics, but the basis for it was an executive order from President Trump to review the regulatory efficiency of all of the federal decisions that had basically been made by President Obama. And we have sort of a parallel thing here. I remember I was saying about the emphasis in the provinces in terms of the most cost-effective approach. Well, you see the parallel thing going on in the U.S. The difference is in the U.S., the development of oil and gas on federal lands in the U.S. is at a much higher level. It's about 1/3 of the lands, whereas here, as we were saying, it's much smaller. In terms of the actual venting and methane, the standards that I was referring to in 2016, they haven't, as far as I know, they haven't been challenged. They're directed towards facilities. So the real change has been with hydraulic fracturing of oil and gas wells. And I say, when we look at what's in our federal regulations, to me, prohibiting venting at an oil and gas well, which is consistent with what we've seen in Pennsylvania. Pennsylvania and Colorado are a couple of the states, a small minority, that have adopted stricter standards. I would argue if you can prohibit venting at hydraulic fracturing of oil and gas sites in Pennsylvania, why can't we do it in BC and Alberta as well? So that, but the 2016 standards that I referred to are still in place, and I'm not aware of litigating those particular standards. No, that's okay.
Hello, thank you very much for your presentations, very interesting. I'll start with just a slight correction. Bill C-69 requires that all projects that will be assessed have to say whether they contribute or hinder our climate commitments. I very much wish it actually said you need to consider upstream and downstream emissions specifically, and maybe that's what the regulations will do. As it is, I think the international best practice, it's been required by courts in South Africa, in Australia as well, and at least half a dozen court cases in the US. Even if the downstream emissions happen in a foreign country over which we don't have jurisdiction. So I was just wondering if you think there's anything specific to Canada's legal regime which would make consideration of downstream emissions not possible.
Yes, you're right. I guess what I was suggesting is that there's scope there for potential consideration of upstream and downstream emissions. And there is the Hydro-Quebec case concerning electricity exports from, I think it's 1994, and that was the case in which the Supreme Court decided that environmental effects of electricity generating plants within Quebec for electricity that was being exported to the U.S. could be taken into account by the National Energy Board, was within the board's jurisdiction. So there's authority there that suggests that potentially upstream and perhaps downstream environmental effects, including greenhouse gas emissions, can be taken into account.
So would you agree with me that maybe the obstacle is not legal but political?
It's all political.
Okay. Thank you.